In boxing, most fights aren't won by knockouts, by the way. They're won on points. It's who has more points at the end of the boxing match. So just like that way, you have to parry. You have to hit them back the way they hit you. Looking at their lawsuit, looking at their contract, looking at their paragraphs, looking at their affidavit. I've yet to see a lawsuit where there wasn't something there that helped my client win or mitigate the amount that they owed. They just don't have any care. Why should they? Most people are going to default. You have to be on top of that court docket. You can create your own court docket, but be on top of theirs. And if they do get you at home, don't sign anything. You make their job so much easier. Even when they've improperly served you or done something wrong and you sign, they say, hey, you got to sign. Don't. You don't require to sign anything. And these 5 things are the most important things I want you to remember about the counter affidavit and answering your lawsuit. Hey, Brian Parker here, doing another exciting video. I guess I've got 480 videos, approaching 500 videos. It's all about the debt collection process. So today we're going to do part 1 of the debt collection process in a schematic way. So let me just put up this graph for you, Shazam. So that is the debt collection process in a nutshell. Whether it's you choose to do nothing, you get sued, you get defaulted, what can happen, whether you choose to do something, how to handle every stage. Today, the stage that we will look at is how to create the most important document, at least from our side of things. That's the counter affidavit. I still get questions, hey, when do I file the counter affidavit? What do I do with it? Is it too late? So I'm doing another video on counter affidavits just to help us keep moving along with the learning process. So things to remember today are your counter affidavit is the blueprint of your case and how to defend against everything the collector is going to throw your way. Use garbage time. I actually call it garbage time discovery. We'll talk about that briefly. And use their documents against them. So there's 2 places where you can get documents to use against them. One is garbage time, and that's before you're sued. And the second is when they sue you. They've got great documents that you can use to complement the documents you get from garbage time. Before we go forward, like, love, and subscribe, and remember to use Parker GPT in your debt defense. There's nothing like it. We're not your average chat box. All we do is every document I've ever done, all my intellectual property is gone into and is embedded in, along with a million cases, into Parker GPT for your debt self-defense. So let's quickly look at the process we're looking at today, and that's the first part of the debt collection process. I would argue the most important part. I know when we look at lawsuits or we look at law shows or stuff that's happening in the news resulting in going to the Supreme Court, that stuff's important. I'm going to say to you, in the debt collection context, what I'm about to tell you is the most important part about winning a debt collection case, and it is that counter affidavit. So the first contact you're generally going to get from a debt collector, whether it be the debt collector or law firm, is that first collection letter. It is governed by the FDCPA 1692G, 15 USC 16 USC 1692G. That tells the debt collector how they must serve you that first notice and what they must notify you about. It's very big. How you respond to that will determine if you can win the lawsuit. Yeah, I said that. So let's take a look. So my favorite video in this context is this one, how to fight a collection lawsuit before it is served. And in that, I talk about garbage time. Garbage time is when you become aware a lawsuit's coming your way in whatever form, and when you're actually served. So you don't need to fear, per se, a lawsuit that's been filed. You fear, if you will, the jeopardy that you start to, you are not in jeopardy until you are served with the lawsuit. So that filing and service, and even that first letter, that's a couple of months where you can do great things for yourself. I'm about to go to trial, first time in trial in a long time since COVID, next week against a big debt buyer. And I always think I'm going to trial. I act like I'm going to trial, and 99.9% of cases don't go to trial, right? It's my first in 6 years. So you have to act like that, because it's generally the other side's not going to act like that. They think you're going to roll over or be part of the 9 to 10 that gets defaulted. But you come in hard. Look at the how to fight a collection lawsuit before it is served video, and it will provide you with the following important letters. You can do these individually. You can use Parker GPT, but there'll be a credit dispute letter, a forward flow agreement letter, a validation letter, a contract letter, a securitization letter, use my Fair Credit Billing Act letter to dispute their usual account stated statements. Just disputing the statements that you receive generally or in the lawsuit is enough to push them back under the FCBA and to set you up quite nicely. But make use of, turn garbage time into problem Parker time, and that equals valuable use of your time. Keep an eye on the court docket. So when you get that first letter, that's a hint and a half for you that something's coming your way. Always treat it seriously. Don't just throw the letter away. I've been there, head in the sand. I've been there. Don't do it. You'll do yourself a big favor. Action cures fear. Be worried and then go to work. And you can beat these guys because they don't put the work in that you do. So here's an example of what it looks like on a court docket. Shazam. So that's LVNV funding versus Johnson. And that shows you what the court docket has online. And you can see there's the attorney, there's a party, and that's just telling you that a lawsuit, and this is date filed, 10/08, that'll probably get served late November, maybe into December. So that is garbage time. So if a lawsuit pops up, use that garbage time and turn it into problem for them time. It will take a month or so and use it. I've looked at this, it's pretty inexpensive. Put a Ring camera on your door. It's good anyway to protect yourselves these days, but that footage can be valuable. You're not required to help the other side if they contact you and say, hey, we'd like to meet you somewhere and serve you. You don't have to do that. And if they do get you at home, don't sign anything. You make their job so much easier. Even when they've improperly served you or done something wrong and you sign, they say, hey, you got to sign. Don't. You don't require to sign anything. If you, again, are caught, if there's the process server serving you, you have to observe everything. Has the processor incredible intimate knowledge of your lawsuit such that he or she has read it and is quoting from it? That's important because they're not supposed to do that. They are technically under the law a third party that the debt collector cannot. I know it sounds weird that the process server cannot look at your lawsuit, but the process server's job is to hand you something. But if it starts reading, then they are, in my eyes, a third party that the FDCPA does not protect, meaning it's a violation of law for the process server or any third party to read your lawsuit and know your important, intimate debt collection details. So look at these videos, if you might. How you can beat improper service. An unwanted visitor shows up. What do you do? Again, those are two good videos to look at the use of Ring camera and what you can do if you're improperly served. Again, keep your eye on the court docket. So if they claim they've served you, it will look like this, Shazam. And it says right there, summons and complaints served personally. And they say that happened on 10/2. If you know that you were in another state or even out of the country on that date, that's beautiful information. You're using court certified information showing that they lied. And you'd be so surprised how many times something makes it up on the court docket that isn't true. So in that case, you can see on the docket, summons and complaint was issued 9/26, and they show when they served this person and for how much. So You have to be on top of that court docket. You can create your own court docket, be on top of theirs. But however you received that lawsuit, you can use the information even if you received it in violation of the law. You likely received the information from the garbage time letters that I had you send out. Now you can use their lawsuit. So as far as combating their lawsuit, look at the following videos. Help fighting a debt by a collection lawsuit -DOA. How to beat a creditor collection lawsuit. Now you take their lawsuit, use their information, their documents against them. I can tell you, I've yet to see a lawsuit where there wasn't something there that helped my client win or mitigate the amount that they owed. They just don't have any care. Why should they? Most people are going to default. So use their information against them. So tear that lawsuit apart, paragraph by paragraph. Read it and go, well, that's true or that's false. Generally, it's all going to be false. And remember a couple of things. Does it have a contract attached? It must be signed by you and be the actual contract that they claim you breached. If it isn't, it's going in your counter affidavit in your defense. Does it have an affidavit attached, as most account stated collection lawsuits have? Tear it apart. Just look at my Destroying Affidavit in Collection Cases video. Does it have a bill of sale attached? Look at my video. Exposed. 9 out of 10 debt collectors use invalid documents. Think of the game Jenga, and the game is you pull a piece of wood out without it collapsing. Then your opponents pull a piece, and the one that loses, it finally pulls out and it collapses. This is the reverse of that. You want to pull out the linchpin that's keeping that thing up as soon as possible. So you've got to look at my linchpin videos. There's at least 3 there, and they are good videos on how to spot the linchpin. And usually is 1 or 2 paragraphs of the lawsuit. You knock that out, you knock out the Jenga. You knock out the entire lawsuit. So how do you do that in a legal lawsuit? A legal way in response to a lawsuit? The counter affidavit. It is imperative, whether your state requires it or not, that you create a fantastic answer, and it all starts at the counter affidavit. So take all that garbage time discovery. What do I mean by that? In court, in law, there are discovery periods. After you go to your first pretrial, the court says, okay, parties, you can do discovery. It means you can discover their defense and they can discover your defense. It allows the free-flowing amount of information depending on what you request, and it usually settles cases if you find out something they don't want you to know, but they have to respond under the law. So take that same philosophy and start sending those letters I told you about before the lawsuit is served. You're allowed to ask as much as you want, and generally a creditor or a debt buyer, a signor will send you this stuff because they don't know there's a lawsuit. They got rid of the stuff. And a lot of times that garbage time discovery information contradicts what the debt collector's bringing. I've seen it time and time again. It can't hurt because it'll always help you in your counter affidavit. So I want to show you an example. In Michigan, if the account stated claim is backed by an affidavit, the collection lawsuit, or other evidence, you have to counter that evidence. You automatically lose the case in Michigan if you don't. That's in Michigan, it's 600.2145. In all actions brought in any courts of the state to recover the amount due in an open account, if the plaintiff or someone on his behalf makes an affidavit the amount due as near as he can estimate and annexes it to the said complaint, such affidavit will be deemed prima facie evidence of your indebtedness, meaning you lose, Charlie, unless the defendant with his answer by himself or agent, the attorney, makes an affidavit and serves a copy on the plaintiff or his attorney denying same. It is statutorily mandated that you lose, at least in Michigan, if you don't counter their affidavit. That's why it's called a counter affidavit. Other states like Florida or New York or Minnesota, some big ones, I'm sure there are more, while they don't have a statute, Michigan's pretty tough both ways. Michigan actually did that law to mess with debtors, so it makes it easier for the debt collector to win. I look at it and go, oh yeah? I'm doing the counter affidavit. In fact, part of the law, and we won't get into this, but if you file it with a counter affidavit, a counter claim, they have to respond with an affidavit. I've never, maybe 1 in a million, I've seen a debt collector go, oh shoot, they've turned this around on us. Usually you've got them. So, but most states aren't codified statutorily like this, but they do have this common theme, and that's if you receive in those states other than Michigan a account stated claim, it's given that it is viable and you're on the hook if you wait an unreasonably long time without objecting. So please do your counter affidavit whether your state requires it or not. You're showing the court evidence of your lack of liability or their bad job, usually their bad job, or both. You always respond to a collection lawsuit with the 3 following things: your answer, your affirmative defenses, your counter affidavit, which is exhibit 1 to every answer. So let that be the solid, bright line, okay? You use the counter affidavit to defend the collection lawsuit. In boxing, most fights aren't won by knockouts, by the way. They're won on points. It's who has more points at the end of the boxing match. So just like that way, you have to parry. You have to hit them back the way they hit you, looking at their lawsuit, looking at their contract, looking at their paragraphs, looking at their affidavit. And that's how you show the judge how great your case is. So you can go to some online service, I'm going to say Solo Sue, for example, and you'll have nothing. You'll have admit, deny, not sure. There's no counter affidavit or explanation of why you win. Or you can use Parker GPT. And these 5 things are the most important things I want you to remember about the counter affidavit and answering your lawsuit. You should create the counter affidavit before your answer. It is a blueprint for the entire case. I've settled most cases after I file my answer and my counter affidavit. It just goes away because if you do a good explanation, the other side is going to, I don't want to deal with this. What do you want, Parker? Well, they'll ask you that same question because they assume the worst about you. So show them your best. Number 2, plug in your parts to the counter affidavit that you created in response to their allegation. So you create the counter affidavit, you take the pieces. So they say, hey, we own this debt. Let's say their number 5 is we own this debt. And you've discovered that they've got the wrong name or the bill of sale is false. Well, you've said that in your counter affidavit. That is your response to allegation number 5 that says they own the debt. Number 3, every defense you have against the collector and any information you have or defenses like statute of limitations, ID theft, misrepresentation, anything from garbage time discovery or your review of their answer goes into your counter affidavit, which goes into your answer, which goes into your affirmative defenses. 4, draw from their complaint, and that goes into your, anything you find in their complaint that's bad, put it in your counter affidavit, telling the court, hey, they said this, but here's the truth. Hey, they're suing me in Michigan, but here's the truth. The contract says sue me in Delaware, if Delaware is beneficial to you. Number 5, if the plaintiff makes a false statement in the lawsuit, where does it go? Where does it go? Counter affidavit, that's right. And then that goes into your affirmative defenses, and that goes into your answer. So you speak to the court through your counter affidavit. The court will hear you. If you file a motion to dismiss, guess what Exhibit A is? That's right, it's your counter affidavit. You're countering their case, and most motions require you have some supporting documents. If you use their documents and incorporate it, embed it into the counter affidavit, that meets most state rules as far as filing a motion to dismiss. You'll obviously add other stuff to show the court why you should win the motion. So your counter affidavit, please remember this. I'll put it up. Your counter affidavit is the blueprint of your case and how to defend against everything the collector has against you. Everything in this video that you can use against them is in Parker GPT, the AI power of it all. Everything I've said and done in 30 years is in my Killdebt.com website, which is embedded in Parker GPT. All this I just told you may seem overwhelming, but a click of the mouse and you've got it all in front of you. You can create your counter affidavit, Tell Parker GPT, create the answer, create the affirmative defenses after you uploaded their stuff, after you uploaded all the garbage time discovery, and you will have a winning document. Just check your work. Make sure you file a proof of service no matter what you do, so the court and the other side are served. But Parker GPT does it all for you. I hope, remember, the counter affidavit is so important to winning your collection lawsuit. Thank you.